See you later, bump stock ban. That's right. Today, the United States Supreme Court struck down the bump stock ban that was implemented by the ATF back in 2018. Now that I have your attention, be sure to stick around as we're going to discuss the huge ruling the U.S. Supreme Court issued today. Hello everyone and welcome back to the Firearm Firm channel. Hopefully everyone saw my short video I released this morning announcing that the United States Supreme Court had just struck down the bump stock ban. To celebrate this huge victory for the 2A community, be sure to click that like button, and if you have not already done so, don't forget to subscribe to the Firearm Firm channel by clicking on that subscribe icon located down in the bottom right hand corner of this video. The case that gave us this victory is Garland v. Cargill. The issue that was before the U.S. Supreme Court was whether or not the ATF had exceeded their statutory authority by creating a rule redefining the federal definition of a machine gun to include bump stocks. One thing the Supreme Court did in the majority opinion, which of course I think is definitely worth mentioning, is that for years the ATF had taken the position that attaching a bump stock to a semi-automatic rifle did not convert the semi-automatic into a machine gun. However, after the tragic shooting in Las Vegas back in 2017, ATF decided to change their position and created a rule that changed the congressional definition of machine gun to include bump stocks. Earlier this year, the U.S. Supreme Court heard oral arguments in this case, and today, June the 14th of 2024, the court issued their 6-3 decision with Justice Clarence Thomas writing the opinion for the majority. Justice Thomas is the same justice who wrote the majority opinion in the 2022 landmark gun rights case, New York State Rifle and Pistol Association versus Bruin, which I know all of you know about by now. The ATF tried their best in this case to persuade the U.S. Supreme Court that they were correct in categorizing bump stocks as machine guns, but the Supreme Court ultimately concluded that ATF exceeded its statutory authority by issuing a rule that classifies bump stocks as machine guns. In reaching this conclusion, the court looked at several things. First, and most importantly, the court found that a semi-automatic rifle equipped with a bump stock cannot fire more than one shot by a single function of the trigger. In the order, Justice Thomas wrote, "Under the National Firearms Act of 1934, a machine gun is any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The statutory definition also includes any part designed and intended for use in converting a weapon into a machine gun. With a machine gun, a shooter can fire multiple times or even continuously by engaging the trigger only once. This capability distinguishes a machine gun from a semi-automatic firearm. With a semi-automatic firearm, the shooter can fire only one time by engaging the trigger. The shooter must release and re-engage the trigger to fire another shot. Machine guns can ordinarily achieve higher rates of fire than semi-automatic firearms because the shooter does not need to release and re-engage the trigger between shots. Nothing changes when a semi-automatic rifle is equipped with a bump stock. The firing cycle remains the same. Between every shot, the shooter must release pressure from the trigger and allow it to reset before re-engaging the trigger for another shot. A bump stock merely reduces the amount of time that elapses between separate functions of the trigger. The bump stock makes it easier for the shooter to move the firearm back toward his shoulder and thereby release pressure from the trigger and reset it. And it helps the shooter press the trigger against his finger very quickly thereafter. A bump stock does not convert a semi-automatic rifle into a machine gun any more than a shooter with a lightning fast trigger finger does. Even with a bump stock, a semi-automatic rifle will only fire one shot for every function of the trigger. So a bump stock cannot qualify as a machine gun under section 5845 subsection B's definition. Probably my favorite part of the opinion is when Justice Thomas calls out the foolishness of the ATF and the dissenting justice's reasoning. He wrote, "Finally, the position that ATF and the dissent endorse is logically inconsistent. They reason that a semi-automatic rifle equipped with a bump stock fires more than one shot by a single function of the trigger because a shooter need only pull the trigger and maintain forward pressure to activate continuous fire. If that is correct, however, then the same should be true for a semi-automatic rifle without a bump stock. After all, as the dissent and ATF themselves acknowledge, a shooter manually bump firing a semi-automatic rifle can achieve continuous fire by holding his trigger finger stationary and maintaining forward pressure with his non-trigger hand. Yet, they agree that a semi-automatic rifle without a bump stock fires only one shot each time the shooter pulls the trigger. Their argument is thus at odds with itself. The court went on to write that while a rifle with a bump stock could not fire more than one shot per function of the trigger, even if it could, it would not do so automatically. Because to fire a rifle with a bump stock, additional forward pressure is required by the shooter with their non-trigger hand. The statutory definition of machine gun is very clear in saying that a machine gun fires multiple rounds per trigger pull automatically. While this definition of course includes holding the trigger down as part of the single function of the trigger, it absolutely does not include the requirement to use additional force with your other hand. To quote the court, the statutory definition of a machine gun does not include a firearm that shoots more than one round automatically by a single pull of the trigger and then some. The ATF made a final desperate argument to try to have their unlawful rule upheld by making an argument typically referred to as the presumption against ineffectiveness. This presumption essentially means that judges should not interpret a statute in a way that renders it useless or makes it very easy to elude. The majority found that their interpretation of the machine gun statute absolutely does not render the statute meaningless or ineffective. The ATF is still allowed to regulate machine guns. A law is not useless merely because it draws a line more narrowly than one of its conceivable statutory purposes might suggest. Section 5845B still regulates all traditional machine guns. Simply put, the majority stated that the regulation of actual machine guns is still valid and enforceable, and the fact that bump stocks allow non-machine guns to be fired more quickly does not prevent the enforcement of regulations about real machine guns. So, as you can see, this is a huge victory for the 2A community. This is going to help set precedent on other issues such as arm braces, FRT triggers, and it really should set ATF in their place and let them know that you cannot just change congressional definitions to fit your agenda. If you have any questions about this video, be sure to leave them down in the comments section. I will attach a copy of the order for anyone who wants to read it in its entirety down in the description section. Until next time, stay armed and educated.